Hi everyone, I just wanted to update everybody about what's happening since the last video I made. So a lot of people know already that I did lose my son. The order came in on September 22nd, 2025. And before the order came in, there was a lot of concerns and issues that I brought up in court in relation to the admissibility of the order, as well as there was a lot of conflict of interest that I was addressing already, that it was made in violation of without a proper authorization, and in violation of Rule 123 subsection 5 of Court of Justice Act, which was made without granting the Chief Justice granting the court any additional time to make a judgment. So there was several issues that was brought. A lot of people knew that I was in the process of filing, or have filed already by then, in documents relating to the judge who made the decision to give my child away. Prior to her making the decision, that I filed documents with the Attorney General of Canada, as well as in Supreme Court and in federal court. And so I do have like all the affidavit of service and the emails that I filed it with several different court and stuff. So and I obviously brought it up with the court where the judge is appointed, as well as with the other parties themselves. I was not I'm not allowed to, as a party, not just me, nobody's allowed to contact the judges directly. So contacting them is via the court staff or councils and parties, and by filing documents with court are the ways of communicating with judges, which is all the steps that I have taken to communicate with the judge prior to her making her decision, informing her of the violations and the laws and the rules and such. Regardless, she still proceeded with making a judgment on my file and gave my child away in September, and it has been very traumatizing for me. And it's been 32 days as of today that I have gone out of my house. I just don't feel like that I have any connection with this country anymore. And without my son at this point, to be honest, there's not really anything else that I really care about in this place. So I don't really actually feel like going out and communicating with people. I do still continue to get various way the court system tries to scam me out of a lot of money by making proceedings longer, by delaying proceedings. All of these is not even for the purpose of uh, you know for what's in the best interest for my family. All of this has been to intentionally cause harm. At this point right now, it has been 17 months that I have seen my son. I haven't been to his birthday last year. I haven't seen him graduate from school. I haven't been to his Christmas parties. I have been completely excluded. I do talk to him online for 30 minutes a week, but per week, but I haven't seen him, touched him, hugged him in over 17 months now. So uh, as of recently, I have started an appeal in Superior Court to appeal the order that my son should be returned back to my care. And I'm just struggling with a lot of delays and non-responses from the court. And it's been very, very difficult. Everybody's giving me a runaround and kind of ignoring me while I'm struggling. That the child that I raised on my own for the past 12 years, that I haven't seen this kid, and that my relationship with him is kind of breaking apart. And I think these people are getting a lot of enjoyment out of it, and it is kind of sickening that I have to rely on them to try to get my child back, because I don't think they have any understanding of how this is affecting my family, and they don't have any understanding towards it. So And recently I asked that on Monday next week, on October 20th, a status hearing is scheduled. It's sort of like a case conference where we schedule like the dates for appeal hearing and when the documents should be filed by each parties, etc. So I requested that a motion for inadmissibility, if the judge's order is admissible or not, should be heard first before proceeding with an appeal, because appeal is very expensive, it's very lengthy. It will take a long time to go with the appeal. So I asked that, maybe we should the court should hear the issues relating the admissibility of the order first prior to deciding if it will be necessary to proceed with an appeal. And the court today, the court said that, so basically I said that on Monday, when we have the status hearing, I would like the court to give us some extra time. So the status hearing is scheduled for 30 minutes. Give us like an additional 30 minutes so that we can kind of go over the issues of the order, why I think it's admissible or not, if it's made in violation of various different issues, and the fact that I filed raised concerns against this judge in different court, and filed documents with the Attorney General, which is the violation of conflict of interest, subsection 1, that if I have a personal difference and argument with somebody, then that person should not be making life-changing decisions relating to me and my son or my family. So I wanted to discuss all of these things, present my evidence in court to determine that if the order is admissible or not, and if the content of the order can be relied upon for the appeal purposes. So for the appeal purposes, I have to show that there are several wrong and false information in there. So I have to prove that I have to go through all the details of the order, and I have to prove that those information is false. But if I can prove that the order itself is inadmissible, then it won't be necessary to actually go through every single details of the order. So I ask that this is heard first to determine that if it will be necessary to actually go through the appeal to address if the order isn't made in violation, if the judge should have made this order to begin with, before deciding if it will be necessary to appeal the order, to go through all the information of the order, because there's like tons of information. It's like hundreds of pages that you have to kind of go through. It will take a long time, and within this time, like I really want to see my son. I haven't seen him in 17 months so far. And so I wanted to schedule the motion. Apparently the Children in Society Council was not available for the entire month, and then she's not available until sometime next month. Now the court is saying that the admissibility of the order should be addressed during the appeal, which can be done. It's not an issue, but the problem is that I'm not willing to spend hundreds of dollars to submit all of the information, review the videos, all of that. I have to go to court. I have to file more USB drives. I have to go to different lawyer's office and submit USB drives with everybody. This is going to cost me a lot of money, and I don't have that much money, and plus I'm not willing to spend that much money, and I don't have the resources to go through all of these things right now. And so I'm not going to be addressing those things, because I know that this order is made in violation of various different laws, and that it has been I made it very clear that she broke like several law, and she had like really, she could not understand like what I was going through. She relocated my child she didn't stop my ex-husband from relocating my son to another city, which was like 2.5 hours away from here. There's like, she denied me to let me see my son for like several months. Like there's been like so many different issues that I brought up, and they didn't take any actions. And I still stayed quiet and allowed them enough time to make a judgment. So the law says that a judge has 6 months to make a final trial judgment. So I did give her 6 months. I did not, even though I did not agree with some of her orders. When I requested to see my son, I did not agree that she allowed my ex-husband to relocate to London, Ontario. All of those issues were brought up after the trial, but within the 6 months, and still I didn't argue about it, because I wanted to give her honor the time that she needed by law, for her to make a judgment. But after the expiry of the judgment, after the 6 months, I filed a document with the court asking that, okay, so none of the parties are looking for extension of time. You do not have proper authorization to continue with this file. Nobody has granted you additional time. I ask that you dismiss this file and you return my child back to my care. And she denied to do that. So when she denied to do that, that was a violation, because she was proceeding with the file illegally at the time. So that was around like September 9th or something. At the time, I had no idea of when a judgment will be provided. There was no deadline, there was nothing. So on September 10th, I contacted the office of the Attorney General, and I filed some documents that I'm having some issues with this person, this judge, and that she was taking various improper actions, like not stopping a person from moving to another city with my child. She was not allowing me to see my son. She was not providing a judgment. She was still proceeding with the file when she was not given additional time. So a lot of improper actions. So I filed some documents with the Attorney General of Canada, and I also filed these documents in Federal Court of Canada as well as in Supreme Court. And I brought up these issues on social media, YouTube, as well as I talked about it, with the other parties, other councils and such, via email and stuff. The court, 47 Shepherd Courthouse Family Court, where Her Honor is appointed, I also contacted them, and I told them via email that there's a conflict before this judge. I would like to schedule a motion to go before a judge and talk about it. And I provided them with the draft notice of motion, and they said that they talked to a local administrative judge, and they asked me to file a 14B motion, which I did. And while I was doing all of that, while her court was notified, legal counsel was notified, other parties were notified, this issue was brought up on social media, various different court was notified, she still proceeded to make a judgment and gave my son away to a convicted felon. So obviously, this has been a hate crime. She still did not provide me with any access. She said that I can talk to my son online for up to 30 minutes, and my ex-husband will decide if I can see my son or not. That's after 16 months of not seeing my son. She wasn't even able to make a decision regarding my access with my son. So obviously and I've never hurt my son in any way, haven't done anything wrong. So for her to not able to decide, like, if I can even see my son for like once a week or so, like, that actually shows that the whole decision has been made by anger, because I spoke up against her. So which is why this order was made in violation of conflict of interest. Obviously she was angry with me, and she should not have made the order relating to my son. She should have waited, or dismiss the file, or ask everybody to come for a case conference and try to find other resolution regarding it, instead of continuing with this out of anger. This is going to affect my son's life, my entire family's life, for a very long time. And all of this has been a very unprofessionally dealt with, and that she should not have taken this action. Anyway, now that all of this is done, like I said, I have been trying to schedule a motion to at the appeal court to try to bring a motion for inadmissibility, because this order should not have been made to begin with, because there has been multiple violations, multiple issues, and she shouldn't have done that. And that this should not even go through a proper appeal. I should not have to bring in trial records and affidavits and witness testimony and all of these things to show that, because the order is inadmissible. Like, it has been made out of anger. It cannot be relied upon as an evidence just so that I can be scammed out of money and I can be put into financial stress, right? Like, this has been done as a hate crime to intentionally try to cause harm onto my family. So but right now the court is saying that the issues relating to admissibility should be heard at the appeal hearing. So now, I mean, I have no other choice. I'm still going to the status hearing on Monday, October 20th, and the judge would be Justice Nakuneshni. She's actually a very nice woman. I'm going to try to go there and explain to her that the issues relating to admissibility of the order and the conflict of interest, all of these things happened like more than 6 months after the trial happened. When people drag on a case, a lot of issues happen, such as the Rule 123 subsection 5 of Court of Justice Act, which says that a judge needs to make a decision relating to a final judgment within 6 months. Because all of these issues happen because she was not, initially started all of this because she did not provide a judgment within 6 months. Obviously, this issue relating to that did not exist at the time of the trial, as since I had no way of knowing when the court will be releasing a judgment. So obviously, so that is not a part of an appeal, because the appeal is supposed to be all documents that was filed before the court during the for the judgment, which is an error. But it is relating to the admissibility of the order and why the order is inadmissible. All of these things happen way after. Like, when I filed my complaint with the Supreme Court, the Attorney General, and the federal court, all of these things happened last month in September, between September 10th and September 18th of 2025. The trial happened in like February 24th to February 28th of 2025. So those conflicts did not exist at the time. These conflicts happened last month when I brought up these issues. When I contacted her court where she is appointed, I think that was sometime in like September 15, 16, 17, something around that time. And so all of the, which was again the week before that when the decision was released. However, these things happened more than 6 months after. So these issues, the orders, the documents that I filed with the federal court, the documents that I served to the Attorney General, all of these things didn't exist at the time of the trial. So that is not an issue of appeal, because at the appeal you bring up issues that was at the court at the time of the trial. These things happen after. Why the issues happen after, and why her honor should not have made a decision relating to my son, and life-changing decisions relating to my family. All of these things happen more than 6 months after the expiry of her making a decision relating to my family. So, which is why the order is inadmissible, because first of all, there was no authorization given to her from the Chief Justice, and obviously that issue could not have happened if she did provided us with the judgment within the 6 months. So obviously that was not an issue of during the trial. And when I complained about it to the Attorney General, Supreme Court, and Federal Court, it was relating to these specific issues. So I could not have complained about it while she was within her rights to make a decision within 6 months. All of those things happen. I couldn't have complained about it. So those things were not an issue at the time of the trial. However, it was an issue after several months after. So why the court wants me to file documents relating to all of these things at the trial, at the appeal, when none of these documents existed at the trial hearing, is kind of beyond me, because it does need to be heard at a motion to determine, first of all, if this order is admissible to begin with, so that they can be used for trial, for the appeal, for the appeal. So I'm not really sure why I'm given run around, or if this is a joke, or I'm being scammed out of money, or if this is obviously looks like a more intentional reason to cause harm onto my family. But yeah, I mean, this would be a serious violation of appeal rules if I'm filing whole bunch of documents which did not even to address inadmissibility, which did not even exist at the time of the trial. And I'm actually not including any documents relating to the trial, because I'm only addressing the admissibility of the order. So it doesn't really make sense. So I'll make another video sometime next week, inform everybody about what Justice Nakuneshni has said in relation to if a motion can be heard. But yeah, I'm not going to be filing a whole bunch of documents relating to the trial. Maybe one or two that I have, but other than that, I'm not going to be addressing anything, because first of all, the order is not inadmissible. So if the other party bring up anything, I'll just point it out. But other than that, I'm not going to be spending unnecessary money. So that being said, I'll inform everybody about what's happening. Things are really, really bad. I haven't seen my son in 17 months, and I'm really worried. His birthday is next month, and I was really hoping that he would be back in my care by then, but I'm not really sure what's happening. And the last thing is that just pray for me that hopefully I get my son back. I mean, he just started grade 9, so as a mom, it's not just about me thinking about getting my son back. I also have to think about what's in the best interest for him. He just started grade 9. This is October. He started his first semester in high school in the beginning of September. So this is end of October, almost November. So he needs some specific credits and grades for him to be able to graduate from high school, and it will be very difficult for him to come back to Toronto, because he's in London, Ontario, and restart a school in the middle of the semester. So I did talk to my family about this, and I decided that well, I don't know when the appeal hearing or the motion for admissibility will be heard, but I've decided that if he did even come back, even if there was order made, I would likely keep him with his father until the end of first semester, which is end of January. So this way, he can finish his first semester in London, Ontario without it affecting his grades. But the only good thing in the situation would be that I would be able to spend my weekends with him. I would be able to call him anytime that I want. I'll be able to visit him in London, Ontario, and help him with his homework over there, or take him to eat or something somewhere in his area, so that he can, at least I can start to rebuild my relationship with him, and that he can perhaps, come stay over on the weekend. He can start to kind of get used to being back in Toronto and start living here. So all of these things, keeping in mind, right, which is in the best interest of the child, I was hoping that, if, regardless of, if the court was willing to hear the motion sometime this month, or I'm still hoping that I will be able to convince Justice Nakuneshni and try to make her understand the difference between an appeal and a motion. So this way she understands why the motion for admissibility needs to be heard first. But I don't know what they will do. But that if I was able to prove that the order was made in violation of several different law, then my son would be returned back to me, and or at least, he will be staying at his dad's house while I get to spend more time with him and rebuild my relationship. I mean, this is kind of worrying me right now, and I am going to go and inform this to Justice Nakuneshni on Monday, October 20th as well. Hopefully she understands that how this is affecting me, and hopefully she will allow us to move forward with the motion without any further delay, before deciding if it will be necessary to go with a full-on appeal hearing. But regardless, at this point, I'm just not going to file any documents other than the admissibility stuff. So regardless, which is, it's gonna be an improper appeal hearing. It will be the opposite of an appeal hearing, where all the documents will be there, like most of the documents will be there, which is like in relation to why the order is inadmissible. Obviously those things didn't exist during the trial, happened way after that. So it's like that's not even an appeal, so it doesn't make sense. So I'm going to try to talk to Her Honor on Monday next week and try to explain this to her and see what she says. But usually when one judge says, this and this, everybody else kind of goes through with it, which I don't think is right. But at least I'll be able to explain my position and see what they say. But I'm not going to be unnecessarily spending money and things. So I know the next I'm not in good terms with the Justice Department. I know the next issue will be like, they're going to unnecessarily delay it like months and months and months later. I mean, obviously they have really bad understanding of how this is affecting my relationship with my son. Although I'm gonna explain to Justice Nakuneshni on Monday that, regardless when the motion is heard, at least this will give me the opportunity to, if the court makes a decision in my favor, at least that will give me the opportunity to spend the weekends and stuff with my son. So I can kind of call my son, contact my son, joke around with him more often, try to go visit him and stuff. So hopefully she understands that it's not that I'm just trying to, despite his education, I'm not caring for his studies, and I'm just hoping that he comes home and then his education goes away or whatever. Like, that's not what I'm thinking. So I'm gonna see what they say, and I'll inform everybody about what's happening. But I anticipate more violation of rights. They will say I have no rights to schedule a motion, and then the second thing will be like hundreds of months of delay so that I cannot spend time with my son. I mean, it pretty much proves that they are trying to break up my family, and it's me and my son, we are under attack, and we are not going to be safe here, which is why we have to move out of Canada as soon as possible. But it's just a matter of time right now. I'm stuck with this. So I guess we'll figure it out once everything goes through. I mean, these people really do get enjoyment out of this, that, keeping families trapped and breaking up families and stuff. I'm not that kind of people. I do see a lot of things happening on social media, and a lot of families breaking apart, a lot of dramas. I read things, people make memes out of it, but I never participate in anything that will break up a family. I don't like share, make memes, or make jokes and comments about people that are obviously going through some stuff. Just because everybody is doing it doesn't mean that I have to. And however, everybody is not like me. Some people get enjoyment and feel powerful over breaking up other people's families. So, you know I have nothing. I don't know what else to do to deal with this, but I know this is affecting me emotionally, especially that it's affecting my relationship with my son. But I kind of have to go through it with it, and I have no other choice. And I'm just hoping and praying that this miserable life ends sooner than later, that I can hopefully someday take my son's hand and walk away from all of this and never look back to this place ever again in my life, that I never have to deal with this. That's the only thing I can think of to try to get away from this. But right now I am stuck here, and I have nothing else. I cannot do anything else other than be forced to deal with this for I don't know how long it will take to fix all of this. So please pray for me that hopefully this is all resolved sooner than later, and that at the end of the day someday I can get to be with my son again, and that I can get away from this place as soon as possible and never come back here ever again.